The nature of international law. Introduction. In this chapter, we focus on the nature and scope of international law. In 2003, when Australia participated in the coalition of Fight Iraq, and the Prime Minister argued that Australian military force participated with just cause in an action properly based in international law. On the other hand, significant section of the Australian community maintained that the war against Iraq was in breach of international law. What is international law, and to what extent does the law constrain or regulate behavior? Most students by now are familiar with other branches of law. The essence of this chapter is therefore to help identify the peculiar characteristic of international law that distinguish it from the other types of law. Most branches of law that you must have studied up to now are concerned with the regulation of the relationship between juridical persons in the Australian community. One could say that your study has been concerned with Australian municipal or domestic law. On the other hand, the relationship between Australia and other states is regulated by international law. It may therefore appear that international law is the body of law that governs the conduct and relationship between states. While this is principally true, one must necessarily treat this definition with caution because it seems to suggest that international law is the body of rules that regulates interstate relations only. This would be misleading because there are entities other than states that may also have rights and obligations under international law. Example of such entities are international organizations such as United Nations, the Association of Southeast Asian Nations or ASEAN, and the European Union. There are also important aspects of international law that concern the right and obligation of individuals and the relationship between individuals and states. For instance, while the relationship between Australia and Indonesia is undoubtedly governed by international law, the law is also concerned with the relationship between Indonesia and its own citizens. Similarly, in Australia, the treatment of Aborigines and human rights issues affecting particular social groups may be matters of concern for international law, as was demonstrated in the Tunin case. It is also important to stress that in some instances, matters that may appear to be essentially of those domestic concern may in fact be subject to international regulation. A good example is that the case of Australia's treatment of asylum seeker and boat people. While Australia undoubtedly reserves the right to determine who enters to the country in accordance with its domestic law, the determination of refugee status and indeed the treatment of refugees generally are regulated by the 1951 Refugee Convention, to which Australia is a party. Australia's treatment of asylum seeker within its domestic law must therefore be consistent with its international obligation under the convention. A proper definition must therefore take account of the full scope of international law. One may thus define international law as that body of law comprising principles and rules which states recognize as legally binding and regulates the conduct of subjects of the law and relates to events and issues which transcending national boundaries are of international concerns. In spite of the concern of international law with non state entities, the emphasis of states, as reflected in the term international law, is justified for two reasons. First, states are the primary subject of the law. Thus, for the most part, international law deal with interstate relations. Second, even where international law deal with non-state entities such as individuals, the rights and obligations created are considered to arise from agreement among states. States therefore remain the source of international law. At this point, it is also appropriate to distinguish between private and public international law. Public international law primarily concerns the relationship between states insofar as their public or governmental function are concerned. Private international law, also called conflict of laws, on the other hand, relates to the activity of individuals and corporates in their private dealing across national frontier. Example of such dealing may be international sales contract and matrimonial causes commenced in jurisdiction different from the country of matrimony. For the most part, private international law deal with problem of choice of law, determining which state domestic law applies in the resolution of private disputes between individuals over issues that are transnational in character. Even though there are fundamental differences between private and public international law, there are also important links. Many aspects of private international law are developed directly as a result of international agreement between states. For instance, the World Trade Organization (WTO), with its attendant GATT 1994 agreement, is an interstate agreement which provides